Welcome back to C2C Journal. Today we're tackling a troubling development in Alberta's legal world. Lawyers are now being required to take training that pushes woke ideas, shifting the focus from upholding the law to enforcing political ideology. Many experts warn this could pose a serious threat to the independence of the legal profession and the rule of law itself. Joining us here today is Glenn Blackett, lawyer and author of his latest essay, The Law Society of Alberta's Wokism Will Dissolve the Rule of Law. In his piece, Glenn explains how programs like cultural competency training and equity mandates go far beyond professional development, raising real concerns about the future of Alberta's legal system. Glenn, it's great to have you. Thank you so much for joining here today.
You're welcome. Thanks for having me.
Of course. Well, let's dive right into it. So, to start, what is the Law Society of Alberta and what changes have we seen there since 2019?
Okay, so the Law Society of Alberta is the regulator of lawyers in the province. They basically decide who gets to practice law and under what conditions, and ultimately, if somebody needs to be removed from the profession, who gets removed and why.
Mhm.
What happened in 2019 was, and it probably started to percolate in about 2018, but in 2019, what they did is they basically went woke, to put it most simply.
Mhm.
They took, for example, one of the major changes they made was they amended a thing that they have called or they adopted a thing, I'm not sure if they had it before, a thing called the regulatory objectives, which was their sort of guide as to how they, as directors of this organization called benchers, are going to exercise their statutory power. Because the Law Society it's a creature of statute. It's created by the legislature of Alberta. It's given a bunch of powers, obviously. And so the Law Society in 2019 came up with this new regulatory objectives document, which set out their different objectives for what they're supposed to do as a law society. And in there, they have some objectives that we would expect, like supporting the rule of law or supporting citizens' access to justice, that kind of thing, because that's what lawyers are supposed to do:
Yeah.
help operate the rule of law and help provide access to justice. But they had these four obligations or these objectives, and then they added another one: diversity, equity, and inclusion.
Mhm.
And in the document, they said, sometimes there will be moments where these different regulatory objectives contradict one another. And so we're not going to be able to comply with all of them. So sometimes we'll just have to weigh the pros and cons and pick one over another. Which is to say that the Law Society, in adopting DEI, at the same time acknowledges that DEI might supersede other interests like the rule of law,
Mhm.
which is very troubling in and of itself. Then about, I want to say a year later, they published another document called the Acknowledgement of Systemic Discrimination, where they basically vilified the Canadian justice system and said that it's shot through with systemic discrimination. And in that document somewhere, they say, oh, by the way, our directors, our benchers are taking this ideological training to make sure that they center equity in decision making, which is no surprise. Like, once you've adopted the woke ideology, there's no other objective that comes close to competing. So at least they were, acknowledging that expressly. So they adopted wokeness as part of their objectives. They started to redefine familiar other terms in their strategic plan. So, for example, they redefined the concept of fairness.
Mhm.
Instead of fairness that the justice system had traditionally understood, meaning, equal access to an open and fair judiciary or something like that.
Mhm.
They defined it to mean basically equity, meaning equality of outcomes. So things aren't fair unless everyone ends up in the same place, kind of a deal.
Mhm.
And then they also amended their rules to permit themselves the ability to mandate culture or competency training
Mhm.
for the first time ever. And then with that power, they mandated that all 10,000 lawyers in the province take this training called the Path. And the Path is ostensibly it's about cultural competency, which is in fact a euphemism for being woke. But what they let's say might also characterize it as is, cross-cultural competency, where if you're dealing with a person from another culture, you know their culture, therefore you're able to provide them, services because you kind of understand better what it is they want and what it is they need, perhaps.
Mhm.
Um, and but if you actually look at the path, this training that they mandated, it was completely saturated in woke ideology. It
Mhm.
was more, I think, a exercise not in cross-cultural competence, but rather an exercise in something that you would call decolonization, which
Mhm.
is the idea that, and the extent of this we could talk about, but the idea is that in order for indigenous people to, I think, let's pick a verb, feel safe in the justice system, to not experience trauma in the justice system, they effectively have to be insulated from Western sort of legal concepts. And so that's not too express in the path, but what you get to at the end of the path is a recommendation basically that lawyers, like the courts,
Mhm.
start to build out this parallel system of justice for Indigenous people to occupy, including parallel court systems. So effectively, when you get to the end of the thing, the recommendation is in order not to traumatize Indigenous people, we need to increase their racial segregation.
Mhm. Sounds very problematic in many ways, right?
Yeah, I
Yeah.
think so. Yeah, many
Yeah.
more than I've mentioned. Yeah,
Yeah. Wow. You also highlight the story of lawyer Roger Sung and his experience. Can you explain what his story is all about and why it matters in this particular case?
sure. Yeah, I would say, first of all, Roger's not the victim of cancel culture or something like that.
Mhm.
Roger is so he was born in China.
Mhm.
He w was raised during the communist, during, obviously, there's been a communist dictatorship there since 1949. I think he was born in the 60s.
Mhm.
But he grew up in the Cultural Revolution, which was a really, highly political and violent period of communist history.
Mhm.
There was a number of sort of different Maoist cultural revolutions of sorts, which killed, I believe the final total was something in the neighborhood of 70 million Chinese people,
Wow.
and completely destroyed their civil society as well.
Mhm.
He was born into that. He became a professor of international law at Beijing University. Because he was ideologically compliant, he was deemed to be, let's say, a safe person to send out of the country. And he basically then was able to escape. He made his way to New York, where he became, or he obtained a degree at the New York School of Law, and then he eventually settled in Canada in 2014. And I think like we see, I mean, I've noticed I'm kind of in the freedom community, and there's a lot of sort of freedom issues happening. In COVID, there was a lot of freedom issues that
Mhm.
arose. And what you really tend to see is that there's a couple of groups that are really keyed into the problems. And one of them is Christians.
Mhm.
And the other one are people who used to live in communist dictatorships.
Mhm.
Because, kind of like, traveling scholars, like in the form of Alexander de Tocqueville or something, they have that sort of background to really be able to comprehend what they're seeing, these
Mhm.
problems they're seeing. And so, Roger's story is that he comes to Canada with a background where he understands ideology. He understands how ideology, if it's imposed on a legal profession, basically dissolves the rule of law. There is no rule of law, there's rule of ideology. And if we go back to the Law Society's regulatory objectives, this idea that where there's a competition between ideology and the rule of law, we'll have to pick one. Well, you always you know which one to pick. So you always pick ideology. That's how it works.
Right.
Um, so that was his background, and he, was just beavering away trying to make a living. And then in 2019, I guess it was, or 2020, he got an email from his law society telling him that basically he's going to lose his right to practice law unless he gets education to become culturally competent. And he immediately recognized what this was. He saw it as a serious problem. And then, he's spearheaded a number of efforts in the legal community in Alberta to try to roll back this ideology in our governance,
Mhm.
including getting members together for a big vote that we lost, um, putting together a piece of a letter to the Minister of Justice and to the Premier asking for some kind of government intervention and in suing the Law Society of Alberta. So he's kind of almost a one-man army waging war on this ideology in our legal profession.
Mhm. And where is that now? You said the first case they lost, but where does it stand now?
So we went to it's an application for judicial review, which is there's two different kinds of lawsuits you can commence. That's one where you say, hey, there's some state agency over here and they're doing something illegal or unconstitutional. Hey, court, do something about it.
Mhm.
So we went to the Court of King's Bench of Alberta. We were there, I can't remember we in July, I believe, making argument, and then we got a decision just recently. That court dismissed the application for judicial review, basically found that there was nothing wrong, but in part found that there was nothing wrong because the court, A, didn't want to look at the evidence of the things that were wrong,
Mhm.
and B, didn't think that the court should weigh in on matters of politics, which
Mhm.
is, we think that the decision's wrong.
Mhm.
Um, our position is that the legal regulator absolutely has to stay out of politics. If
Mhm.
they get into politics, that's something that the court needs to intervene to correct. And in our view, it's perfectly within the court's jurisdiction to make that correction, even though it
Mhm.
has something to do with politics.
Mhm.
So we're now considering an appeal to the Court of Appeal.
Okay. So currently now, lawyers in Alberta are still required to take this training if they want to keep their license, essentially.
Well, I mean, it was kind of a once and done piece of training. I mean, not, I shouldn't say that.
Yeah.
There was a training was mandated. Everyone had to finish it by, I can't remember, October 2022 or something like that. And all 10,000 lawyers did it except for, I can't, a handful of about 55. Those 55 lawyers were suspended immediately and automatically until they finished it. And I gather that most of them that didn't do it out of any kind of conscientious objection. They did it because they had forgotten or whatever, missed the deadline.
Mhm.
So I think basically 100%, including myself,
Mhm.
of the profession was required to and did comply with that training.
Mhm.
Um, when we look at the Law Society's materials, they say that in the materials they say, okay, it's called the path, right?
Mhm.
Um, one part of that title, which is interesting, is that it's a path somewhere. Where
Yes.
are we going on this path? Well, we're going to go to the next step and the step after that. And so if we look at the materials that the Law Society had to produce in this litigation, we see that their plan was, and I can only imagine still is,
Mhm.
that this was I think I can't remember what term they used, but basically some sort of foundational learning that we would then build off of.
Mhm.
So so there's more to come.
Mhm.
I think they may have made some public statements that, oh no, there's nothing more to come, but I don't, there's no assurance of that. And they also, they mandated that training in part because, which I find kind of unbelievable, but the Truth and Reconciliation Commission calls to action. There's 94 calls to action to different governments and universities and a bunch to the justice system. One of those calls to action required mandatory education like the path, but it also required mandatory education in other areas that I don't really see heavily covered in the path, including anti-racism. So we can expect, I think, more training.
Mhm.
But then we have to pan out a bit. There's another major problem which we have, which was not only did the Law Society mandate this ideological training, they also amended the concept of competence.
Mhm.
So rather than legal competence, meaning if I were to summarize it best, the competence to fulfill your duty of loyalty to your client and to the law effectively, They amended that to mean that a lawyer should also be pursuing in their professional practice this political objective of advancing wokeness and this political objective of seeking out systemic discrimination wherever they can find it and dismantling it. So they've been assigned a specific political objective that they're supposed to implement as they go about their business as lawyers. Now the they in the materials they talk about using sort of light touch regulation at the beginning of this process. They talk about for example, they say, well, okay, we have these new competencies. We don't expect every lawyer to be able to satisfy all of these competencies, right now, but we do expect after a few years that every lawyer is going to be able to satisfy these competencies. So there's an indication in their materials that they're going to twist this ratchet.
Mhm.
First, they've just introduced it as this is a new kind of competency. As you can see, competency requires that you do certain things, that you not do certain things, that you say certain things, that you not say certain things. But they haven't, so far as I know, gone to take somebody's license, for example, yet, because those have been breached. But you don't create an entire new area of competency and then as the regulator just ignore it when lawyers demonstrate incompetence. And so, I think what we're seeing is the thin edge of the wedge.
Mhm.
I think that the Law Society is probably waiting for the dust to clear somewhat for us all to get accustomed to the idea that this is a new form of competence, and then they'll proceed to sort of ratchet up the pressure.
Oh, wow. I mean, it just sounds so contradictory to what a lawyer is supposed to do in the first place, is to be unbiased in every possible way, and to defend their client. Ultimately, that's their job. But now it sounds like they are pushing them to be more activists rather than lawyers, which is very concerning. In your professional opinion, what is the danger of requiring lawyers to complete this kind of training? And what do you think are the broader implications for the legal system and the public as a whole?
Well, I mean, like I said, the where you adopt an ideological objective, and your job is instead to be operating a system of the rule of law,
Hmm.
the ideological objective is going to tend to basically dissolve the law, the legal component. And
Hmm.
by that I mean, let's take an example. Okay. So the rule of law requires that there be some system for a citizen whose rights have been denied to seek access to justice, right? And
Hmm.
the lawyer is supposed to be their guide or their advocate on that journey.
Right.
So let's say that we have, I mean, I have a client, Frances Widdowson, for example. Okay. And Frances Widdowson was canceled at the University of Lethbridge because she wanted to come in and talk about the risk of cancellation to academic freedom. Um, she's a politically incorrect client, right? She's got politically incorrect things. She wants to do politically incorrect things. What does she want to do? Well, according to the woke ideology, what she wants to do is she wants to come onto campus and traumatize or re-traumatize Indigenous students. She wants to destroy reconciliation. She wants to impose or, support systemic discrimination in the form of white supremacy that is open inquiry at universities, et cetera. Okay, so she's a persona non grata to the ideology. So
Hmm.
Frances Widdowson, who gets canceled, and her, I would say her charter rights and also her, other legal rights are denied.
Hmm.
She would go looking for a lawyer. Well, the first thing that a lawyer that's woke is going to do is decline to represent her,
Hmm.
right? So she's going to have troubles finding a lawyer that would even take the file. So by the lawyers adopting this ideological perspective where their job is to dismantle systemic discrimination, well, if they're supposed to take on a file where they're promoting systemic discrimination, they just won't take on the file.
Hmm.
So that's a demonstration of how this works. And then if we carry that example forward, let's say then the lawyer reluctantly takes on the file, and now starts to give advice to Frances Widdowson. Well, this woke legal ethics tells lawyers that instead of just listening to the client and saying what is it you want, here's your legal options, here's the restrictions, here's what I can do for you, what do you want, the lawyer is supposed to actually judge what is it that that client wants and counsel the client or try to shape the client's objective itself. So
Hmm.
Francis says, to her new lawyer, well, I'd like to, get a legal remedy against the university for this thing. And maybe the lawyer says, well, geez, maybe we could go softer. Maybe we could seek a sort of a conciliatory meeting or something quieter. We'll try to modify her legal interests, which is not that's not a lawyer's job. The lawyer is the advocate. The lawyer is not the referee. The lawyer is not the counselor, right? So again, the rule of law dissolved in that respect.
Mhm.
Then the lawyer goes to court for Frances Widdowson. The risk of the lawyer downplaying her case, refusing to advance arguments which might be provocative,
Mhm.
um, are all present. And therefore, if she finds a lawyer and if the lawyer actually agrees to take on her case and goes into court, the chances of her getting effective, robust, zealous advocacy from her lawyer is diminished.
Mhm.
And then, of course, if that lawyer years later gets appointed to the bench, well, you've got a judge in front of you that also sees it as their position not to dispense justice in accordance with the rule of law. What does the law say should happen on these facts? But rather will look and say, well, an equitable outcome to this, which is not, I mean, let's not get confused. There's a concept of equity, but this is a different kind of equity.
Mhm.
That's not what a lawyer is supposed to do. So,
Right.
so that's just the tip of the iceberg in terms of if lawyers adopt these ideological objectives, how the rule of law exactly melts. But the rule of law melts, and with the rule of law, so too go all of the constitutional principles that the rule of law um, affects. So, for
Mhm.
example, democracy, uh, legal equality, non-discrimination, pluralism, uh, freedom of speech, freedom of religion, you name it. All of your, even contractual certainty. I mean, ownership of your property.
Mhm.
It's just sky's the limit in terms of how much this could affect Canadians over time.
I mean, it sounds very concerning. And finally, what is your main takeaway from your essay and from our discussion today about the risks these changes pose to the rule of law?
Probably that it's a I think it's probably got to be a political solution.
Mm-hmm.
We've gone to our members. We called a meeting, and there was 4,000 of the 10,000 lawyers called in Alberta who showed up to this meeting, which is an incredible turnout.
Mm-hmm.
And 800 voted for our motion to get rid of mandatory education. About 3,500 or something voted against us. So I would say that I don't know that that's representative of the entire profession, but I would say that we probably don't have a sufficient mass of lawyers that's interested enough or educated enough about these problems
Mm-hmm.
for lawyers themselves to do something about it.
Mm-hmm.
And there's obviously a lot of pressure on lawyers to not do something about it because when you raise your head above that parapet, you're going to get it taken off by your colleagues and clients and so on. So there's a lot of pressure for lawyers not to do something about it. We've gone to the court, obviously, and at the lower court, we completely struck out. Court didn't think it was appropriate to look at the evidence, didn't think it was appropriate to think about the issue. I hope if we appeal, we'll have better luck at the Court of Appeal, which leaves our last hope really as the provincial government. The provincial government created the Law Society of Alberta. The purpose of the Law Society of Alberta is to ensure that lawyers maintain the rule of law. And so if what the government gives, the government can take away.
Mm-hmm.
The government has announced a review of professional regulation in Alberta.
Mm-hmm.
And we've encouraged the government to basically pass some very clear amendments to the Legal Professions Act that say, under no circumstances is the Law Society to be engaging in any kind of political objective
Mm-hmm.
whatsoever. And so, I think for Albertans, what Albertans should be doing is putting pressure on the provincial government in any way they can
Mm-hmm.
to pass that legislation and pass robust legislation. Not we can't be tinkering around the edges. It's got to really attack this problem at its root.
Absolutely. Well, best of luck to you, and I hope you guys get this going and we see some positive changes in this.
Me too. Thank you very much.
Of course. Well, thank you, Glenn, for sharing your thoughts and insights. To read Glenn's full essay, we highly encourage you to check it out in the link linked in the description below. The essay is titled "The Law Society of Alberta's Wokism Will Dissolve the Rule of Law." Again, Glenn, thank you so much for being here, and thank you to everybody for tuning in. We'll see you next time.